just picking up Gilly's earlier question, it's not an easy question to answer in a sentence. It's something that we come across a lot in London because obviously many of our students come from different countries, and the concepts, if you like, the legal principles are very common. So you're likely to come across the same kind of issues in many places in the world. But as Reham's pointing out, it varies from country to country, and in some countries, and especially, I mean, obviously, if we're talking about certain parts of Eastern Europe, certainly the Middle East, many countries in Africa, sort of China, there are different perceptions of what the extent of free speech is. So, I mean, certainly what the concepts that we're talking about, the laws vary in different countries within Europe, but the general principles are very much the same, and the concepts as far as human rights are concerned will be upheld by the Europeans in the same way. How those concepts are delivered on the ground, from Zimbabwe to Gambia to wherever, are obviously going to differ widely, and it's fair to say that, I mean, journalism is a pretty dangerous business in many parts of the world. There are a couple of hundred journalists die every year, and they generally don't die in war zones. I think it's fair to say that sort of most journalistic casualties, tend to be closer to home with their own governments in countries where free speech isn't perhaps valued in quite the same way. So there are certainly many countries in the world where journalists are routinely sort of arrested and beaten, and where it isn't safe to criticise the regime that's in charge. And also different interpretations of the law can mean that something which, say in Britain, you might say, well, it's your Article 10 right, freedom of expression, to have a view on something. And we've just had a journalist jailed for 20 years in Afghanistan for criticising the Prophet Muhammad's views on women, the Quran. So the interpretation on specific laws is going to vary very greatly. So that means that if you're operating in a part of the world where there is a tough regime, then I mean, obviously anything that we're saying about the law specifically relates to England and Wales, and I think it's fair to say that as a working journalist, you really need to familiarise yourself with laws on the ground, actually working. We were talking about key risks. We've mentioned libel, the protecting individuals from having their reputation damaged, and because that's perhaps the most interest to most of you, certainly those of you on freelance courses, I'll come back to that in a moment. But we equally, when it comes to libel, we need to know circumstances where we can safely expose wrongdoing. So in other words, we need to know what the main libel defences are. Katerina makes a good point that yes, the safety, it needn't necessarily be the state clamping down on you, and I think the same would be true in certain parts of South America, that the position of organised crime means that there are certain stories that would be very dangerous to Gilly, the point about declaring your you asked, where do we stand on recording conversations? Under British law, well, in terms of ethical, to start with ethics, I mean, I think there's a normal presumption that the starting point in general is that as a journalist you declare yourself at the start and say who you are. I mean, that's part and parcel of most phone calls and so on. Are you actually breaking the law by not, first of all, declaring yourself, and secondly, by actually recording what's said to you? it's not a breach of British law to do so unless you're actually, I mean, obviously, if you were tapping into a phone conversation, that kind of thing, that would be breaking the law. And also, I mean, the situation as a journalist is that you are basically a member of the public. So if you are, for example, you're phoning a garage to investigate a consumer story, then you don't necessarily, have to declare yourself as a journalist if you are wanting to see how a normal consumer would be treated. Clearly, it would be different. There are laws against, for example, as we said, sort of wiretapping, phone tapping, that kind of thing. And there are also certain laws preventing you from pretending to be a police officer or so on. But generally speaking, recording what's said to you, if there's a good reason, I mean, obviously, much ethically depends on what you hope to gain by not declaring yourself. And I think if it's the type of consumer story where you know that somebody is not going to be open with you because you are a journalist, then it may be legitimate to say, well, I want to be treated as a member of the public, and not say anything, in which case, I mean, companies tend to say in their, when you phone up the bank and so on, and they say this conversation may be recorded, it's slightly different for companies than if you're making a phone call as an individual. Confidentiality and privacy. Confidentiality, first of all, is a long-standing part of British law, and relating not just to companies and company secrets, but also to individuals and sort of kiss and tell type stories. So there can be issues of confidentiality, and when is information considered confidential, and when would it be in the public interest to reveal it? So that would relate to both, as I say, company secret that somebody's leaked to you, or two people talking about a relationship. At what point would it be breaching the confidentiality of one of the partners to speak to the other one about the relationship? And again, in those kind of circumstances, traditionally the arguments have come back to public interest. Increasingly, since we mentioned Article 6 and Article 8 and the right to privacy being into force in law in 2000, and that's probably been one of the areas of the law that's developed perhaps most, mainly because Britain traditionally hasn't had a specific Privacy Act, if you will. And also our approach to privacy has perhaps been rather different from some of our European neighbours, where countries like France, for example, just across the Channel, have tended to have quite stricter sort of rules about privacy. So if there's been one area of reporting that has changed a little since the Human Rights Act came into force, it's perhaps been the consideration of what we regard as being private and what we feel that we can expose. And I think the changes that you can probably already see in the papers, for a start, I think in the past 3 or 4 years, you've probably seen a reduced number of pictures of children in terms of actors' children and so on, because there are ethical guidelines about not featuring children without their parents' permission just because of the fame or notoriety of their parent. So there's still not a problem if stars are parading their children around matches and so on. But quite a few actors and other personalities have taken steps to protect their children from publicity. There are ethical guidelines in force.